I want to thank you all for joining us. My name is Heather Singleton. I'm the Chief Operating Officer for the Rhode Island Hospitality Association and the Rhode Island Hospitality Education Foundation. Today we have Dan Spears, who's the Vice President of Industry Relations and Licensing with BMI, Broadcast Music Inc. We also have Alden Parker, who is a regional managing partner of Fisher Phillips, a very large firm. And Alden, you are based out of California, I believe. So I appreciate you joining us today.
Yeah, no, happy to.
Thank you. We can have, if any of you have questions throughout the presentation, please go ahead and enter those questions into the chat. We will get through both presentations here, and then we'll get to some Q&As. So I will turn it over to Dan to kick us off.
Well, thank you, Heather. I appreciate this opportunity, and thanks to the entire team at the RHA. We value this relationship so much. Thank you to Dale and Caroline and the rest of your colleagues. Copyright and music licensing, obviously not the sexiest subject matter, but we're going to try and bring sexy back, Alden and I. We're going to spend some time, talking about, well, now here we go. This is what we're going to talk about in our presentation. We're going to kick things off on actually a very cool, positive note and talk about a recent survey that BMI did with NRG on the impact that music has in driving traffic to venues. We'll talk about music copyrights because obviously that's the foundation for what we do. We'll discuss what's licensable in your venue, who the performing rights organizations that actually administer the licensing process. That can be the most confusing part about this, as you hear from all these different acronyms and wondering, are they legitimate or are they being scammed? Then Alden's going to talk about the legal ramifications for not licensing music. I'm going to take a few minutes to talk about what we've done to partner with an online booking platform for those that are considering starting a live music program but aren't really sure how to go about it. And then Alden will continue to discuss copyright issues, specifically how they relate to unauthorized use of photos on websites and social media platforms. As I said, we partnered with National Research Group recently to take a look at, what does music, what role does music play when it comes to a customer making a decision about where they're going to go eat, what drinking establishment are they going to frequent? And I'm going to run through this very quickly because there's a lot of information here and we can get very granular, but suffice it to say that most people, as you can see from some of these statistics, really look at music as a huge part of their decision-making process. 82% agree that the type of music that a business is offering tells you what kind of establishment that is. 83% agree that good music at a bar or restaurant creates more memorable experiences. 79% said they'll stay longer at a restaurant or a bar if good music is playing. Almost 60% will buy more food or drinks just to hear more of the music. So suffice it to say, music can play a very big role in the experience that you have at a restaurant or a bar. And this entire survey is up on our website if you want to explore it more deeply. So into the copyright aspect of this presentation, which is really what the foundation is for what BMI does. The copyright law protects all forms of intellectual property, whether it's music, images, as we'll discuss in a few minutes, movies, literary aspects. If you're a brewer and you make a specific brand of IPA, that's intellectual property. So really the copyright law was established to protect those sort of intangible rights that people actually own. And the kind of rights that are contained within the copyright law as it relates to music, there are several of them, but I want to kind of frame the public performance right, which is the right that BMI represents, with some of the other rights, just so you understand the landscape and how songwriters and artists make a living. We'll start at the bottom and move our way up. So a synchronization right is the right that's held by the songwriter and the publisher. And what is a publisher? A publisher is the entity that represents music. They're the ones that bring life to a song. So as a songwriter, I choose to affiliate with a publishing company. And the publishing company really goes out and serves as an agent for my music, trying to get those songs recorded or placed in television shows or movies. And in exchange for that, the publisher gets the copyrights to those songs. So the question one would ask is, why would a songwriter give up ownership of a song? Well, because that song is not going to generate any income at all unless somebody gets that song out there, whether it's with a recording artist or in a movie or what have you. So that's the role the publisher plays. And the synchronization right is the right that the publisher, the copyright owner, and the songwriter hold jointly. And it's when a song is played in a movie or a television show or a commercial, you need to negotiate that synchronization right with the actual publisher, copyright owner of that song. Mechanical royalties, many of you are probably familiar with this. This is when a song is digitally downloaded or there's a physical copy sold, whether it's a CD or vinyl these days, which is getting traction again. A piece of that income goes to the songwriters and publishers. Used to be a large revenue stream for our songwriters because if you got a song on a George Strait album, regardless of whether the song was ever on the radio or not, he was selling millions and millions of copies of his album. So you would be sharing in the income that came as a result of the sale of that product. Well, now no one's buying albums, right? It's a singles world. And so to get songs that create income for you as a songwriter, you really need that song to go on the radio. And when it goes on the radio or is played in a bar or a restaurant or a radio station or a brewery, that's when the public performance right kicks in. And that public performance right is held, again, by the publisher and the songwriter. So when music is played in a variety of different venues, whether it's a theme park or a streaming service, that business needs to license that music. This is pretty much says it all, that BMI's role is to make sure that public performance right is protected, that the songwriters and publishers are paid a fair and equitable fee for their works. Now, what is licensable in a business? When do you need a public performance license? Well, when the radio is played, there's some exemption in the copyright law, which we won't get into the specifics now. If you're a smaller business with a small amount of square footage, it's very possible that you are exempt from having to license a commercial radio station being boomed into your particular business. But most businesses that are large and have 5 or 6 speakers and have a commercial radio station broadcast into their public space, they need to get a license agreement for those rights. Of course, live music is probably the most obvious aspect to the public performance right. DJs, many people have DJs in their bars or restaurants at night, and that is also licensable. Karaoke, that's still a very big form of entertainment in many establishments, and that is considered a public performance of music and requires licensing. This is the most confusing aspect of the copyright law. Sometimes as the messenger, I get beaten down a bit, but I didn't create this aspect of the copyright law. But believe it or not, under the copyright law, you as a business owner are responsible for the audio coming out of the television set in your bar or restaurant or hotel. Even though you may have a commercial license with DirecTV to allow you to actually broadcast in your business, the audio itself is not included in that right. So you have to get a public performance license to license the audio, the music that's coming through the audio of the television set, whether it's the halftime music or episodic music in a television show or any kind of music that's coming out with a commercial. You're responsible for that as the business owner. Of course, if you don't want to bear that responsibility, you turn the audio off. A lot of people do that. If you have a commercial music service, background music service, Pandora, Spotify for Business, Mood Media, Soundtrack Your Brand, the good news is if this is the only kind of music or form of music that you have in your business, you do not have to license with any of the performing rights organizations because those commercial music services are doing that on your behalf. They have license agreements with all the performing rights organizations. They're paying all the performing rights organizations. So if this is the only kind of music that you have in your business, you don't have to enter into any agreements other than the one that you have with your background music service. Now, if you have your own personal subscription with Spotify or Apple Music and you create a playlist and then plug your iPhone into the sound system at your business, then you do need to license that, because that is not the commercial license with Spotify. That's just you as a personal subscriber. So you still need to license that on your own with the performing rights organizations.
Dan, I have a question. Do you mind if I
Sure.
jump in about this previous slide?
Sure.
This had come up recently where somebody had one of these to use their music on, but then they had trivia, and they brought in someone to do trivia who'd like to play songs between each round, and realized that that was not covered through their license because it wasn't being played through this. Can you just clarify that a
Yes.
little bit?
Yes. So let me backtrack even further. So the commercial music services, the agreements that they have with the performing rights organizations, and we'll talk about the various PROs in a minute, it's a very specific right that they have secured, and that is the right for background music service to be played in a business. Once that music is used in an interactive way, then that requires a separate license directly with the performing rights organization. So, for example, that business that does trivia, and they have Pandora for Business, who indeed pay licensing fees to BMI, ASCAP, and CSAC. However, they're only paying for that ambient public performance of music. If people start dancing to that Pandora for Business, or if they start using clips of Pandora or Mood Media for a trivia game, that is not included in the rights that have been granted to those commercial music services. So you, as the business owner, need to enter into agreements with those performing rights organizations. Does that make sense?
Yes, thank you.
Yeah, it's a very narrow right that they've been granted. Once it becomes interactive and there's dancing and trivia, then you need to secure your own agreement. Very simple, but this is what BMI does. We play the middleman in the process. Songwriters and composers write songs. Publishers own that right, as I said. They own that catalog of music, those copyrights, and then we go out and grant the permission to publicly perform the work, whether it's, as I said, a radio station, a bar, restaurant, or a television station. This is what I used to call the circle of life until someone said, Dan, this isn't actually a circle, it's a square. So this is the square of life at BMI. A songwriter joins, affiliates. It's free, by the way, to affiliate with BMI. So most songwriters at a very early age will choose to join a performing rights organization. Those names that I list are great examples of artists who are also very competent songwriters. But to be honest with you, most of the songwriters we represent, you've never heard of. But if I put those names up there, they wouldn't mean much to you. But I just want you to know that when you pay licensing fees to BMI, you're supporting many anonymous songwriters who sit in Nashville in a writing room trying to write a hit song, and you don't know their names, but they rely upon those fees you pay. So we collect and license, collect royalties from a variety of restaurants, bars, hotels, fitness centers, you name it. We track those performances, determine how often the song is played, and then every quarter we send out a royalty check with a statement to our songwriters. If you happen to be in a business that uses music that's not written or composed in the United States, if you're an Irish bar or what have you, you can be assured that we work with all of the other organizations internationally that do what we do. We have reciprocal agreements with all those organizations, such that when you are playing Irish music in your bar, when you're playing whatever, Japanese music, we are licensing that on your behalf. And they're doing the same for us. So if, Taylor Swift's got a big hit in Tokyo, Japan, the Japanese performing rights organization, JazzRack, is collecting those licensing fees from businesses, paying it to BMI, and then we're including that in the royalty check to Taylor Swift. And then vice versa. If there's a big hit song in the US that was written by, Ed Sheeran, who's with what's called PRS, which is the British equivalent of BMI, we're tracking that. Those performances and paying PRS so they can pay Ed Sheeran. Okay, this to me is one of the most important slides when it comes to sharing knowledge with you all, so that you feel empowered when you get a phone call from one of us and you feel helpless because you're confused about the copyright and you don't really understand where everybody is coming from. And that can be a problem because you don't want to affiliate or engage in a license agreement just because you feel like you're under the threat of copyright infringement. You want to know what it is that you're getting, what you're paying for. So the first two organizations we're going to talk about are the two biggest, right? BMI and ASCAP represent 90+% of the marketplace. Of all the music that you're hearing on radio and bars and restaurants, 90% of that music is represented by ASCAP and BMI. ASCAP is a membership-based society, a not-for-profit that was founded in 1914. BMI was created in 1939 as competition to ASCAP. The broadcasting industry got together and said, hey, ASCAP is a monopoly. They're increasing our fees by 100% every year. We need to create a competitive music source. The other thing that was happening at the time was that ASCAP had very strict requirements on who could affiliate with their organization. You had to have at least 2 established hits on the radio in order to affiliate with ASCAP. The problem is, when these new forms of music came from Appalachia, if any of you watched the Ken Burns country documentary, you learned that so much of the music we hear today, their foundation of that music comes from Appalachia. So all these new forms of music were coming in from Appalachia. Radio couldn't play it because there was no copyright compliance mechanism to do so. ASCAP wouldn't affiliate them, because radio wouldn't play them. So it was a catch-22. So when BMI was created by the radio industry, not only did it bring the rates down because it was a competitive music source, but we opened the door to new forms of music. We said it doesn't matter if you have any hits on the radio, you can join BMI, which is why our affiliate base is so rich in country and rock and roll and the Muddy Waters of the world and the Little Richards and the Chuck Berrys. So BMI had a lot to do with the explosion of new music in America back in the late 1930s, early 1940s. There's a third organization called CSAC, which was created right around the same time as BMI, a little earlier, much smaller. They are a privately held company owned by a venture capital firm. They do have some high-profile songwriters, so you do need to have conversations with them. You don't want to ignore them. They represent Green Day and some others. But I would recommend that you have conversations with CSAC when they come to you and they say, hey, you need a license with us. You've got live music. And they charge you or want to charge you a number that's equivalent to BMI and ASCAP. You need to push back because their market share is much smaller than BMI and ASCAP's. I also need to mention, and this is really important, BMI and ASCAP operate under Justice Department consent decrees. They were created for antitrust purposes. And one aspect of that consent decree is very significant when it comes to your business. And that is, we must treat similarly situated businesses in a similar fashion. That means we cannot negotiate the fees. We create a standard rate, we create a standard formula for determining those fees, and we cannot waver from that. So you cannot negotiate with BMI or ASCAP. We are prohibited by law from doing so. So just keep that in mind. CSAC, you can. They don't operate under any consent decree. You can negotiate with them, and I would recommend that you do if they price those fees aggressively. You know, if BMI and ASCAP are about $400 a year, which is pretty standard, and CSAC comes in at a similar rate, I would push back because their percentage of the market is minuscule compared to BMI and ASCAP's. Similar to Global Music Rights, it was founded in 2013 by Irving Azoff, a very high-profile music industry executive, managed the Eagles for many, many years. He decided he wanted to create a catalog of music that people could not do without. So he brought Bruce Springsteen over from ASCAP, Bruno Mars, Pharrell Williams. He's got some high-profile names. They don't represent a huge percentage of market share, but they represent enough, and they've got high-profile enough songwriters that you need to pay attention to them and have a conversation when they call. And then the fourth performing rights organization, fifth, that's just come on the scene, that's created a lot of disruption and confusion, is a company called Alltrack. And they represent primarily independent songwriters. It's a very good chance that your business has no need for an Alltrack license. But here's what I suggest before we move on from this slide, is that with any of these organizations, you need to find out what it is that they represent that you're going to be playing in your business. ASCAP and BMI partnered a few years ago in creating a database called SongView, which gives you any information you need about just about any song you're playing, who wrote it, who owns it, who publishes it, contact information, so you can be rest assured that you are playing whatever product it is that you've chosen to license, that you actually are using it. CSAC, same thing. They've got a pretty good searchable database. Global Music Rights, I told you about some of the songwriters they represent. Go to their website, learn more about them, but ask questions, particularly when All Track calls you up, because they're the new game in town, and say to them, hey, what is it that you are offering that I'm going to be using in my business? Send me a list of the top 10 most performed songs in your catalog, the top 10 most commercially viable songs that you represent. And then you'll get a much better idea on whether these are performing rights organizations that you need licenses with. Because it is true, ASCAP, BMI are pretty standard, and a lot of co-writes take place between ASCAP and BMI songwriters, CSAC sometimes as well. But these newer performing rights organizations, they sometimes come in and they throw out copyright infringement, and it's scary, right? And if you don't know, much about this business, which a lot of people don't, it can be intimidating, and they can be pretty aggressive. So just make sure that you ask those questions. Who do you represent? What is it that you think I'm using in my business that would require a license agreement with your performing rights organization?
And real quick,
yes,
because I get this question sometimes. Are there instances where you'll have a song and there will be a license on that song with several different or two different PROs?
Yeah. So, yeah, you make a good point, Alden. It's like, particularly in Nashville, collaboration is what happens with songwriting these days. Very rarely do you have one songwriter composing a hit song, particularly in the hip hop genre and certainly in country. So what could happen is, to your point, is that a song could be written by an ASCAP songwriter, a BMI songwriter, and a CSAC songwriter. And it's a hit song, and that would require a license agreement with all three of those performing rights organizations. So that's why I'm saying is that it's really difficult for restaurants or bars to monitor their music use and say, I'm only going to play BMI songs. I'm only going to play ASCAP songs. I'm only going to play CSAC songs. Really hard to manage that, particularly we're in the business of trying to sell food and beverage, and that's how you make a living. And so you have to be very careful because there's so much cross-pollination or collaboration going on. What do you get from a BMI license? Well, the good news is that it's a blanket agreement, which gives you access to over 20 million songs, 1.3 million songwriters and composers. Honestly, I know sometimes you aren't in love with performing rights organizations. We can sometimes be a little more persistent than you like. But I will tell you that if BMI didn't exist, or ASCAP didn't exist, you still would have to go to all those songwriters that you're using their music and license with them directly. So BMI actually was created to make life a little easier so that you can get a blanket agreement and be done with it, not worry about negotiating agreements with all the BMI songwriters that you're playing music. And frankly, when you pay those licensing fees, yes, as Alden will tell you in a minute, there is a copyright law that says you must, and your lawyer will tell you that you should. But also understand that when you pay those licensing fees, you're helping to support the creation of new music. You're supporting the craft of songwriting, because without those licensing fees, without that monetary compensation, songs aren't going to be written. Music's not going to be flowing the way it does today. So there has to be some ability for these writers to make a living, and you are a huge part of that ecosystem. So thank you for all you do to support BMI songwriters in paying those licensing fees. Speaking of which, when you pay licensing fees to BMI and you're a member of the Rhode Island Hospitality Association, as a restaurant member, not a hotel member, but a restaurant member, you receive up to a 20% discount off your BMI fees. We've enjoyed a long-term partnership with the RHA. We love them, and I think it's been a wonderful partnership, the two organizations. And now I leave it to the lawyer to give you the bad news.
Well, this is where I always come in, and I think they bring the California attorney in particular because we're so litigious out here that there are so many lawsuits that get filed, and so we have a particular bent in this area. I should go ahead and identify what hat I wear. I represent the businesses in this instance. And usually not the copyright holder. And so here I'm typically defending someone that's being accused of violating some sort of copyright law. And it's important to know, I'm not going to go into a bunch of legal jargon here, but this law has been around a long time. It started in the copyright law of 1976. It was recently amended in 2022. going into effect in October to go ahead and deal with some of the new types of media where copyright may be infringed upon. And we've talked a lot about music here, but it's important to understand that this can deal with images. It can deal with names of different actual dishes on your menu, or the way in which you describe, if you're a brewery, a beer. We have a tremendous amount of brewery restaurants out in California that go ahead and brew their own beer. And those IPAs all have incredibly interesting names, and those end up going ahead and are copyrightable properties that you can go ahead and own. I'm sorry about some of the background noise that you all may hear. I'm actually in a hospital with my son here in Indiana, so you're hearing some bells and whistles that are not specifically about him, but just some background noise. But I'll trudge through here. So that's the background of the copyright law. There's statutory damages. Obviously, $30,000 is nothing to sneeze at. It's very rare we see a willful infringement designation where it's $150,000 for a copyright song. But one of my leading questions that I asked Dan about, can a single song be covered under several different PROs, is because that does come up in litigation, and you have to be very, very careful about what songs you are playing. If you're using Spotify for Business or Pandora for Business, that newer technology has helped quite a bit, because those groups are collecting the fees and making sure that each of the aspects of the song played are being covered. But where we get into trouble is when we start going ahead and having karaoke or live songs, and we're not vetting the playlist. And if we don't have the proper coverage for those events, we see a lot of restaurants that we end up going ahead and running afoul of the law. So we want to make sure that we at least let everybody know. There's been a pause during the pandemic. I think a lot of the PROs stepped back. They have partnered so long with a lot of the restaurant communities that they saw the impact on our business and held off asserting certain rights or infringements. And quite frankly, for a while, we didn't have patrons inside anyway, enjoying some of the music that we play. We are seeing an uptick in enforcement, not simply by one PRO in particular, but certainly across the board. We're seeing increased enforcement, especially where there are some pretty common violations. Many of the PROs will initiate a discussion with you first, and that's the first instance where you may want to get an attorney involved, or you may be negotiating with the PRO at that point to try and go ahead and get a license that covers your specific type of music. That could be outside versus inside. Largely, it's dealing with square footage of your establishment, that your rates may go ahead and change depending on those types of factors. But those are all things that have to be considered. And when you first get this, that comes up, when you first get notice of it, that's when you want to go ahead and engage and either negotiate with the person that you're talking about, getting a license from, or contacting an attorney and make sure you're going to defend yourself okay.
Okay, great. Just a couple seconds to help people understand, we talked about this a minute ago, but when you pay licensing fees to BMI or ASCAP or CSAC or any performing rights organization, the goal of those PROs is to make sure that those songwriters and publishers are fairly compensated. Understand 100% that that's our mission at BMI. Our job every day is to make sure that songwriters are fairly compensated for their works. So when you do pay those fees, please be rest assured that they're going to the right place. This is a really important slide for those businesses that have live music and are supporting local or regional artists that come in and play in their businesses. So let's say I'm Dan Spears. I'm a local singer-songwriter in Providence. I have not had any traction at all with my music in a mainstream way, meaning my music is not being played on commercial radio stations around the country. Understand that commercial radio still is a very important revenue stream for our songwriters. And the way we pay out our royalties is based upon data that we secure through Shazam technology, right? We have listening stations all over the country that pick up the digital footprint in songs, and then we pay out the royalties based upon those performances. And in that pot of money is not only the money that we're collecting from the radio industry, but also the money we're collecting from the bars, restaurants, breweries, and hotels, because right now we don't have the technology to track what's going on in a small tavern in Tuscaloosa, Alabama. Maybe someday we will, but right now our policy is, or our formula is based upon the fact that if it's being played in a bar or restaurant, it's probably what's being played on the radio and vice versa. So we use that same formula in distributing those royalties. However, with one major exception, and that is your local singer-songwriter, Dan Spears from Providence, Rhode Island. You're playing every Thursday night at your favorite bar or brewery or restaurant, and you're playing maybe 10 or 20 or 30% cover songs, but the rest of the songs you're playing are your own originals that have not yet gotten traction on commercial radio. And you are affiliated with BMI or ASCAP or CSAC, because all three of these organizations have programs like this. Ours is called BMI Live. And what it means is that after every performance that a songwriter or artist performs at a bar or a restaurant, they then upload their set list of original music that they performed that night, and they will get paid based upon those songs being performed in that licensed bar or restaurant. And the reason why I say it to you all right now, even though we may not have any songwriters on this call, is that as a business owner, if you make sure that those songwriters who are affiliated with BMI, ASCAP, or what have you, and they're playing original songs in addition to covers, please tell them to make sure that they're reporting that music to BMI Live through BMI Live, so that they're getting fairly compensated, and so that the money that you're paying BMI in licensing fees is going to the right people, right? If you pay, the average, I think someone asked this question, what's the normal fee? I would say most bars and restaurants, pay in the $400 range a year to BMI, right? Well, if you're paying $400 to BMI, you want to make sure that a piece of that is going to that local singer-songwriter that you're supporting. You've paid them $250 a night for their artistry as a musician and an entertainer, but as a songwriter, that money is coming from those BMI fees that you're paying. So please encourage any of your local artists to make sure that they use BMI Live if they're a BMI songwriter.
Dan, one
Yes.
legal point to that, because earlier you talked about one of the benefits of the PROs was the aggregation, where a business can go to one single source and get access to a lot of songs. If you are going ahead and having a local musician come in and play original stuff, and they're not even signed up with any PRO, the default under the Copyright Act would be that you are actually going ahead and going to have an individual license from them for their songs. And they would individually negotiate that. Now, if it's a relative, obviously that's helpful. The negotiation should go pretty well. But we all have to be cognizant that if we are contracting with someone to come in and play their local music and it's original stuff, either they own it and we're contracting directly with them, or they've gone ahead and signed up with a PRO and the license fees would cover it from there.
Right. Or, and I hate to say this because we don't want anybody to bypass BMI, but let's say you're a small business and the last thing you want to do is pay licensing fees. And you have a local singer-songwriter coming in on Tuesday nights, and they happen to be affiliated with BMI. And they're only playing original songs, no covers, just their own songs. And you're like, this person's affiliated with BMI. I can't have them play in my bar or restaurant because I don't have a BMI license. It is legally allowed for you to go to that songwriter and ask them to bypass the relationship with BMI and directly license that music to you. So you could do a deal with them. That's, our agreements with our songwriters do not prevent direct licenses. So you as a business do have the right to negotiate with that songwriter directly and say, hey, can you bypass BMI and I'll pay you a fee that I think is fair and equitable for that relationship that we have. I don't encourage it because I think BMI, I think it's important for someone to be affiliated with BMI for a lot of different reasons, but we won't get into that. But that's a possibility. I have to be honest and tell that to you.
My concern, Dan, there is that anytime it's sort of like once the horse is out of the barn, right? It's tough to
Right.
get the horse back in.
Right.
Once you start that music and they're interacting with your customer base, your customer may go up there and tip that person to play a certain song
That's true.
that wasn't on the pre-vetted
Right.
playlist. And all of a sudden you're getting into a copyright infringement that you didn't anticipate. You tried to control it best you can. You go ahead and take a big risk going ahead and doing that. Just be careful when you're going ahead and bringing that in, because once you start down the path, you lose some control.
Right. Right. If someone yells Freebird, I mean, you got to play it, right? Play Freebird. Really quickly, sometimes I don't want to assume that everybody on this call is already using music and wants to know what their legal obligations are. If you're considering a live music program and don't know where to start, we have a great partnership with Gigmore, which is one of a number of online booking platforms where you can go in and say, hey, I'm in Providence. I'm looking to book a country artist for Saturday night. Gigmore will spit out all the different artists and bands that are country in your area, and then you can negotiate a deal with them through the Gigmore platform. It actually works really well, and it's a good way to start if you don't have your arms around the local music scene. We created this partnership because we wanted to try and help rebuild the live music programs, post-COVID. And it's just a very simple way to connect live music consumers with the musicians and songwriters themselves. So that's my spiel. I don't know, Alden, did you have some other things you need to touch upon?
Yeah, Dan, there was one more point I wanted to make specifically for the group. We've talked a lot about music, and I started to touch on the fact that you could name certain dishes, or you could go ahead and name certain beverages that you have in a unique way that would also be something to copyright. We are seeing an increase in claims where people are grabbing imagery from the internet, which is a copyrighted thing. It doesn't end with just music, the Copyright Act of 1976, but it goes ahead and covers those images. And sometimes we will take something that highlights Monday Night Football and we'll put it on a certain section on our website, or the Super Bowl is a big one, or maybe even Golf Masters or something like that. But events, sometimes images of performers. And all of those are owned copyright instances where you can definitely go ahead and run afoul of that area, and someone would be reaching out to you. The ability to go ahead and search the internet and comb it for where those images are, go ahead and lead to a lot of people being able to track down copyright violations where 10, 15 years ago, we didn't see it. Because you were handing out flyers at that point, maybe 20 years ago. Now with the internet and the proliferation of it, we're grabbing images from different places, and we think, oh, well, if it's not blurred out, that must mean that we can go ahead and grab it and use it. And that's absolutely not the case. You can definitely run afoul of this law, and we're seeing increased enforcement there, mainly because of the ability to track and go out and see that those images are out there on people's websites.
Alden, I have a question then with that. So
Sure.
if as a business, if you're designing, maybe it's a new special, or you're introducing a new menu item, or you're hosting, you've got some, I don't know, you're hosting an event or something. Where, if you don't own those own images, like Dan Spears, for everybody, or for those of you that don't know, Dan Spears is a phenomenal photographer.
Nice.
Follow his work, nature photographer. But if you're not a photographer yourself,
Right.
Where can you go to use images or get images without violating any copyright law?
Yeah, I mean, a lot of people that I know use iStock photo because there's the ability to purchase the right to use the photo in a certain way, and that goes ahead, and then they operate a lot like a PRO in music, where a segment of that money that you paid iStock ends up going out to going out to the artist that created that image or the personality that owns that image. And so you can go ahead and do that. It's just so easy now to drag and capture an image that might be out there on the internet that you see that people are doing it. And I won't say there's a huge number of these lawsuits yet, but the proportionate increase in suing businesses that are using images on their website is quite significant.
Thank you. Does anybody have any questions for either Dan or Eldon? Reminder, you can put your question in the chat if you'd like, or we've got a few minutes before we end if you want to just raise your hand and ask. Dan, it looks like Mark just posted a question. I think this one is definitely for you.
Yeah, so Mark, if you have Mood or Pandora, obviously, as a background music service, and they've covered the licensing fees on your behalf. However, that does not include live music. Now you say you've paid ASCAP big money in the past. If you were doing live music at the same time as offering Mood Media, then you would be required to pay ASCAP, BMI, CSAC for the rights to have live music in your particular establishment. Now, when you say you paid big money to ASCAP, it's possible that both BMI and ASCAP have these a la carte kind of menus where you check off what you're doing. If you're doing just live music, then that's all you would check off. But then there's karaoke, DJ, recorded music. If you checked recorded music, then you basically were double paying because Pandora was paying on your behalf. And then you also were paying for the recorded music. So anything outside of the recorded music, anything outside of background music, live music, karaoke, that would be your responsibility to license. Let's see. We even had a letter of proof of license sent to ASCAP. Can I force them to refund my money? Well, if you've paid ASCAP, again, if you've paid ASCAP for that recorded music in addition to paying the live music fees, and you've been doing this for a while, yeah, I would try and show proof that I had an agreement with Mood and Pandora for the last year and you overcharged me for the recorded music. I would try that. I don't know what kind of success you'll have, but I would definitely look into that and see
Dan,
what kind of, yeah.
Maybe I could speak to that. So
Sure,
I think
sure.
Certainly your initial approach is going to be person to person, whoever your relationship is at ASCAP, and you're going to approach them and say, hey, look, I double paid. I had Pandora Mood, and I got talked into signing this agreement that I really didn't need. I just needed the live. And you might get a certain response there. If you were to really push it, the legal aspect of it is you would probably have to show fraud and a fraudulent inducement to enter into the contract, that you were misrepresented by whatever salesperson you were talking to, that you had to have the item that was already covered by Mood Pandora, and you let them know about that you had Mood Pandora, and they said you have to have this anyway. You would have to have that type of claim, and it's a pretty difficult claim to go ahead and sustain. But if there's a lot of money at stake, it could be worth it.
Well, I have another question. What if what if there's an innocent infringement? Like you don't know what you don't know. And is there a particular, what should somebody do? Is there like a certain amount of money or like an average settlement or something that somebody would pay? What advice would you have there?
Well, the innocent infringement is $30,000. It can generally be negotiated during a lawsuit. You will sometimes see those negotiated, but the attorneys that are prosecuting copyright infringement, they know that they've got something where they can get $30,000 and they get attorney's fees on top of that. So it's very difficult to get them to move much off of that number, even in sort of the innocent copyright infringement. The law really places the onus on the establishment to make sure that when something's played in their establishment, they're covered somehow with one of these copyright services. The more intentional infringement is the one that's very, very expensive. It's $150,000. And there's a harder burden of proof to show an intentional infringement where you knew you were violating it, you were on notice, and you went ahead and did it anyway. But those could be very, very dangerous cases. So I think my straight answer is the innocent infringement is expensive to begin with. And it really puts an onus on making sure we're not violating this. We in this day and age where it's much easier to go ahead and sign up with some of these either PROs or the music service like Spotify for Business or Mood Pandora, much better to go that route for most of your music.
And Mark, to answer your question, yes, you can only license music, 1 or 2 times per week. The agreement has that ability for you to determine, what's appropriate for you. Is it 5 times a week? Is it 1 to 2 times per week? And that, of course, will impact what you pay. So yes, we absolutely offer that as an option. I will tell you, just going back to what Alden was saying about copyright infringement, at least when it comes to music and public performance, I can speak from BMI's perspective. If you're using music without a license, BMI will have reached out to you dozens of times before we'd ever consider taking any legal action. We send, 5 or 6 or 7 very marketing oriented forms of communication. Then if we don't get any response, those letters get a little legalistic. Sometimes attorneys get involved in writing those letters, but we're about educating, because the last thing we want to do is file some sort of lawsuit against a business that just didn't understand what their obligations were. And these are businesses that are going to be our customers going forward, right? So the last thing we want to do is sue a restaurant or a bar or what have you. So you will have heard from BMI many, many, many times before there's any possibility of something legally significant occurring. It does happen, as Alden says, now that we're sort of post-COVID in a sense, there are some lawsuits that are being filed, but I promise you're not going to get a letter all of a sudden out of the blue that says we're suing you for infringement. You will have heard from BMI many, many, many times before that.
Yeah. Some of the disruptors have a shorter fuse though. So
Correct.
some of the more recent folks that aren't subject to a consent decree and the way that they go about doing things, you may see a bit more aggression on the forefront there. So, it sort of dovetails with the second question that was up there about can I just go with BMI and not do ASCAP? It all depends on the music being played. And so if the music being played is completely covered, meaning all the songwriters for that song, the performer, the producer, if everybody is under the BMI umbrella, then you can do a BMI license and the set list would only be BMI completely covered works. But it's a dangerous game to play.
Hard to do. As much as I'd like to tell everybody, take a BMI license, that's all you need. You'd have to really manage this process. You'd have to go on to our Songview repertoire and make sure that none of these bands or song artists are coming in and playing anything that's not 100% licensed through BMI, as Alden says. And it can be a time-consuming process. And as I said, yes, I'd like to think music is an important part of your business, but it's not your business, right? Your business is creating a wonderful dining experience for your customer and selling a lot of your food and your beverages, and who wants to be spending all that time managing music licensing? But it can be done. It's just not easy.
Yeah. And there's another question here regarding images. Is it permissible to use an image from an artist's social media account to promote an upcoming event? And again, that image itself could be owned by the artist. We don't know ultimately whether that artist has copyrighted a certain image with them in it. Some of them do. And so it becomes very precarious to just grab these images off of the internet. We should do it with a lot of caution. It is a new frontier, both in social media that they've gone ahead and posted, along with who has the right to go ahead and enforce that.
I just sent a link to the song view repertoire. When you say, how can I get a list of your clients, singer-songwriters, the list is, it's over 1 million something. So I'm sending you a link to that song view repertoire, which contains a lot of great searchable information.
I have a question about use of images. I work for a nonprofit organization. I produce our email newsletter. It goes out by email to selected audience. And I use Shutterstock and other services like that to get some of the images that we use, or they're our own images, etc. I was wondering if there's any consideration for the size of your audience in terms of using a copyrighted image. Obviously, it's something always to avoid or to get permission to use. But if a mistake were made, say, does it make any difference whether it's potentially seen by 10,000 people or 1 million people?
Yeah, there were some amendments in 2022 that dealt with this question and really lowered the threshold for visual images and visual copyright, so that it would be very hard to stay under the amount of people that could potentially view the image. It'd be very difficult to do. So most people are using some sort of service that they've signed up for where images come with that service, like the ones you mentioned, Shutterstock or something like that. And those are images that your monthly fee ends up covering the royalties relating to that image.
Mm. And if someone took images that belong to the organization that I work for, and we didn't like the way they used it, say, they used it in a way that made us look bad, for example, what is our first step for taking action?
Generally, first step is a cease and desist letter, or you take what a lot of the approach is of the PROs, where they write to someone and say, hey, look, you're using this image. You need to enter into an agreement with us. You violated our copyright. But where you're not really in the business, the hypothetical you gave is you don't like how the image is being used or how it may blow back and feedback and provide feedback for the organization. Your likely first step is a cease and desist.
Mm-hmm. Okay, thank you.
The good news, Gary, is that sets up the more egregious action. You're putting them on notice of the violation. And if they continue to use it, you're going to have a bigger threat that they've intentionally gone ahead and violated a copyright.
Right, because they've been warned, so to speak.
Correct. Yep.
Great, thank you.
Dan, there is one more question. Oh, no, actually, this question came to me directly. Sorry about that, Carmen. So they're asking if we have Spotify for Business, or they just want to confirm this. If they have Spotify for Business, then they do not need a separate license unless they do live music.
Unless they do live music, karaoke, DJs, or they're using that Spotify for Business music in an interactive way by offering dancing or trivia in association with it. As long as it's just ambient music and that's all they have and it's through Spotify for Business, then they're good to go.
Great, thank you. Okay, any other questions? I'm going to put Caroline on the spot here. Caroline is our Vice President of Membership and Business Development. Caroline, I don't know if you have any last I don't know what announcements or invitations for anybody. I know we've got a packed schedule coming up, so I wanted to give you an opportunity, if there's any reminders you wanted to give the group.
Thank you, Heather. Let's see, next week we have Women in Hospitality. We're coming to Newport at O'Brien's. So if you can join us for that or have any ladies on your team, please send them out. That's going to be June 6th. And then the following week, we will be at the Capitol Grill for our annual membership reception on June 14th. Both registrations are open on our website. And that's it.
Great, thank
Okay.
you. And I think we lost Alden here, although, oh no, he's here. There he is.
There he is.
I knew you were moving.
He's mobile.
There is a note in the chat, Alden, sending wishes for a speedy recovery to your son.
Thank you very much. I
our-
appreciate it.
Rhode Island family is rooting him on today.
Great.
I second that.
I appreciate that very much.
Great. And Dan, thank you very, very much. Longtime partner of our association. I really appreciate you taking the time.
Heather, thank you. Thank
okay.
you. Anytime you and Heather, you and Dale or Caroline call, I always answer the phone. Thank you.
All right, everybody. Have a wonderful week. Thank you for joining us. Let me know if there's any follow-up questions and we'll see if we can get some answers for you.